Hello everyone, it's Rick. It is August the 27th, 2026. It's a Thursday. And today's video is about courts. And let's learn about them, their limitations, so you can avoid child support orders. Once you understand the functions of the courts and what is needed to determine personal and subject matter jurisdiction, you can better fight child support. Okay? So, how do you reach me? Okay, if you're willing to exchange a gift of my determination for paperwork and coaching through email, and sometimes I do it by phone call as well, consultation to challenge and stop child support. You can send your email to the addresses below. Always check your spam folder for my response. Please use all my email addresses to ensure I receive your message. Okay, these are the addresses below. Please click like. It takes 2 seconds. If you're not already subscribed, please subscribe. It doesn't cost anything. It helps the algorithm tremendously to reach others. This is not the same YouTube it used to be. So we have to work harder to reach others. Okay, so here's the introductory statement about the courts. Okay, a substantial part of this information comes from 20 American Jurisprudence, 2nd edition, Courts, about courts. American Jurisprudence is a secondary source that identifies legal principles and cites cases and statutes. Courts are governmental bodies created to administer justice. Justice is the truth. You can't administer justice without knowing the truth. By determining facts, applying the law, and resolving disputes between parties. Unlike administrative agencies, which are not courts and generally operate within the executive branch, focusing on future regulation. They're trying to prevent wrongs. They're not trying to prevent them. That's a big thing. Courts belong to the judicial branch and primarily address past wrongs. That means the judicial branch, that's their duty, is to address past wrongs. No evidence of wrong or wrongs, they have no jurisdiction. The plaintiff has no standing. A court's authority depends on both subject matter jurisdiction over the controversy. No controversy, no subject matter jurisdiction, and personal jurisdiction over the parties involved. So they need to prove personal jurisdiction. If they're lacking in these two things, the court lacks jurisdiction, the plaintiff lacks standing. It's a principle of law that law arises from the facts. No facts, no application of law, statutes, which means you have to force them to prove the facts. This is why we have to understand courts. Without properly established facts and lawful jurisdiction, as shown in the record, a court cannot validly apply the law or issue a binding judgment. There's other things involved in the judgment, but let's focus on facts. Courts in general. A court is an organ of the government consisting of one or more persons authorized to administer Justice. Another word for justice is the truth. Although administrative bodies may hear and determine facts, and in this respect perform judicial duties, they are not courts. Okay, I think I discussed it in the last video that administrative agencies are not courts, but they're allowed to use hearsay. But hearsay is not admissible in judicial courts. So what they do is they take hearsay from the administrative agency, and then they introduce it into the judicial courts as fact, and this is where you have to challenge hearsay. Courts may distinguish from administrative agencies in that courts are part of I'm not a professional communicator. In that administrative agencies, in that courts are part of the judicial branch, whereas administrative agencies are part of the executive branch of government. Remember, we got 3 branches of government: judicial, legislative, executive. They're all separate. They all have their own specific duties. In addition, administrative agencies do not have the power to punish contempts, which is one of the inherent powers of court. That's very important to understand. So an administrative agency cannot hold you in contempt or have you arrested for contempt. Understand that. Courts, the nature and distinctions administrative bodies distinguish. Furthermore, while administrative agencies prospectively, which means technically in the future, preventing a wrong, oriented, setting down rules to be followed based on laws passed by the legislature, the function of the courts is much narrower, usually addressing themselves to problems after the fact. Judicial courts are used to remedy past wrongs. If a court is a creation of the legislature establishing court guides the determination of the court's authority. This is Oakley v. State of Michigan. This is a Michigan case law. Functions, powers, and duties of courts. Courts are created to ascertain the facts in a controversy and to determine the party's rights according to justice. Remember, justice is the truth. One of the primary goals of adjudicatory proceedings in the uniform application of law application, which relates a legal standard of conduct to the facts established by the evidence, is analytically distinct from the other 2 tasks courts typically engage when deciding a case: law declaration and fact identification. The application of a specific law or a set of laws to a record of established facts. No established facts, you cannot apply the law. No evidence, no facts, no application of law. Okay? I think I just said that. Okay. So, here's the principle of law. I just screenshotted this from Wikipedia. It's ex factis jus oritur. Okay, read that. It's a principle of law, or a maxim of law. Courts, jurisdiction of person. Jurisdiction of the person is the power of a court to bring before it the person to be affected by the judgment and to render a judgment binding on that person. The power of a court to decide a case as to jurisdictional matter requires the court to have personal jurisdiction over the person or party, as well as subject matter jurisdiction over the controversy. A court's personal jurisdiction refers to its power to impose judgment on a particular person. You notice how they use the word particular person? Well, they're legal persons, like an obligor. Were you born an obligor? No, you have to agree to be an obligor. And there's ways to become an obligor. Signing a birth certificate, acknowledgement of paternity. But did you know that they were offering you that? So when you were signing the acknowledgement of paternity in a hospital, did you know that you were acknowledging an offer to accept the benefit of child support, or that you would be bound by supporting that child according to the guidelines of child support? You didn't know that, did you? Well, that's okay, because that's not a consideration. And I've touched on that in the past, but you have to know you're being offered a contract. If you don't know you're being offered a contract, it's not a contract. Okay? A court's personal jurisdiction refers to its power to impose judgment on a particular person. Judgment rendered by a court lacking personal jurisdiction is void. Okay? A note on special appearance. A claim verbally, this is what usually happens. You'll state that you are challenging personal jurisdiction, and that you're there to object by special. Your special appearance is you're there to object to personal jurisdiction. And what usually will happen is the fact finder, the judge of the tribunal, the child support court, will say, well, we have a personal jurisdiction, and they just want to move on. Well, what you need to do is you say, no, we're not moving on. I'm not moving on until you prove it and I want it on paper. It's my understanding that courts communicate through written orders. Okay? That's just one way. That's the way I do it with my people. So just read that. That's what it says here. Pleading personal jurisdiction, the burden of the pleading. The plaintiff bears the initial burden of pleading allegations sufficient to confer the court's personal jurisdiction of the defendant, including the burden to plead facts sufficient to bring a non-resident defendant within the reach of the state's long-arm statute. A challenge to personal jurisdiction may be raised either as an affirmative defense in the answer or a motion to dismiss for lack of jurisdiction over the person. In the absence of the defendant's contest of the issue, the court treats the plaintiff's allegations of long-arm jurisdiction as established. What they call it is liberally construed, which the claims are presumed true until you challenge it. Okay, really what that is, they're allowed to believe the presumptions, and you have to challenge it. Do you know how to do that? I do. So if you want to do that, leave the writing to people that know how to do it, like myself. Okay? Not everybody can write, and ChatGPT, trust me, can't do everything. I know there are a lot of experts now with ChatGPT. Courts, mode of acquiring jurisdiction. Generally, a court with subject matter jurisdiction may acquire personal jurisdiction by the parties, pay attention, consent, agreement, waiver, or estoppel. Estoppel means the case is stopped when it's proven that the plaintiff has no right to bring a suit. A party's consent is if you do not challenge jurisdiction, as I said before. Agreement, also they love having people sign agreements. Then it becomes a contract. And then you have to prove that you only signed the agreement because they forced you to. Unless you have a video that I'm holding a gun to your head, you're going to have a very hard time doing that. As a general rule, the court's personal jurisdiction over the parties may be conferred by their consent, whether express or implied, by the parties' particular acts or by agreement or contract, such as forum selection clause, though not necessarily a choice of law provision. Personal jurisdiction can be conferred. Again, we're going over the same thing. Waiver, estoppel, and general appearance, meaning you just show up and you don't challenge jurisdiction. They're allowed to assume that you're there ready to go. A party waives personal jurisdiction defense by failing to raise it in a timely manner. You got to do it right away. Administration of justice, generally determining law, role of public policy. The courts have the authority to do all things necessary for the proper administration of justice. The judiciary has the inherent authority to manage its own affairs, make rules, and carry out other incidental powers when reasonable and necessary for the administration of justice. As also stated, the courts have reasonable control over all proceedings connected with pending litigation in order to ensure the orderly administration of justice. A state Supreme Court has the ultimate authority over the judiciary's inherent administrative functions. So that means you would have to appeal to the Superior Court in your state, or the state Supreme Court. We'll deal with that another time. The authority to investigate, determine, and sanction judicial misconduct contained in the state constitution is a mechanism to ensure that the justice system maintains the respect of the public that is essential to its mission as the third branch of government. A state Supreme Court has the authority and the duty to prevent the misuse and abuse of the judicial system. Rendering decisions or opinion. A court speaks through its decisions and not through its opinions. In rendering a decision, the court determines the facts of the case and applies the law to those facts. However, in a case tried by a court with a jury, it is the exclusive province of the jury to find the facts, and the trial court's duty is to see that the functions are intelligently and justly performed. In making their decisions, the courts are greatly influenced by judicial precedents, prior decisions. Generally, appellate judges are free to write almost anything in their opinions regarding the decision of the case or the facts and the law involved in the case. However, the discussion must be germane to the case at bar and the facts that are within the record of the case. The court's decision and its opinion can be announced at different times. Here's the conclusionary statement. Courts are governmental bodies created to administer justice by determining the facts, applying the law, and resolving disputes after a controversy has arisen. Unlike administrative agencies, courts belong to the judicial branch and possess inherent powers and judicial powers, including the power to punish contempt. A court's authority depends on both subject matter jurisdiction over the controversy and personal jurisdiction over the parties. Personal jurisdiction may be obtained through proper pleading, consent, waiver, estoppel, agreement, or appearance, but it must be timely challenged when disputed. Without properly established facts, lawful jurisdiction, and evidence appearing on the record, a court cannot validly apply the law or issue a binding agreement. And a note on that, I can't tell you how many cases I've seen where they don't have any established facts. There's no evidence. Rarely is there any evidence entered, if any time. So this is why it's important to know how to do this. So that is it. Let's remember. Here's how you can contact me. And if you're still here, please click like, please subscribe. It helps this channel's algorithm tremendously. Thank you. I'll talk to you guys soon. Bye.